everyone. Welcome to our last session of the academic year. We will conclude our journey with three important updates to be presented by three excellent speakers, which we are delighted to host. Our first speaker will be Yael Ronen, a professor of international law from the Academic Center for Science and Law in Hod HaSharon, a research fellow at the Minerva Center of Human Rights at the Hebrew University in Jerusalem, and the academic editor of the Israel Law Review. Yael will discuss the third Palestine v. Israel communication, recap, and admissibility update. Our second speaker is Eitan Diamond, the manager and senior legal expert at the Yaconia IHL Center in Jerusalem. He has previously served as director of the NGO Gisha, as legal advisor of the ICRC and for B'Tselem, and in addition, he was an expert consultant in UNICEF, at the OHCHR, and more. He recently completed his doctoral thesis at Tel Aviv University's Tzvi Meitar Center for Advanced Legal Studies, in which he examined the interplay between law, war, and media. Eitan will discuss some observations regarding the establishment of an international commission of inquiry to investigate violations in the occupied Palestinian territory, including East Jerusalem in Israel. Last but not least, our third speaker will be Advocate Amir Cahane. Amir is a research fellow at the Federman Cyber Research Center Law Program here at the Hebrew University of Jerusalem, and in addition, he is a researcher at the Israel Democracy Institute dealing with online surveillance law. Amir will discuss the European Court of Human Rights Grand Chamber decision in Big Brother Watch versus the United Kingdom. Let's get to it. Our first presentation is by Yael, but I see that we have a problem with the PowerPoint.
No, we don't. If we do, then not yet. I haven't tried to set it up.
You were patiently waiting.
So this time at this point we're still okay. Okay, so let me just set something up here. So what I'm going to speak about is the decision that was given by the third committee. It's the committee that oversees the implementation of the Convention on the Elimination of Racial Discrimination. So the convention is called CERD, the committee is the CERD committee. It's a decision that was given last month, determining that the Palestinian complaint against Israel is admissible. So just a recap on what we're talking about. In 2018, Palestine submitted a complaint under the interstate complaint procedure to CERD, in which it attributed to Israel responsibility for violations of the convention, namely a practice of racial discrimination as well as apartheid. Now, this is a 300-page complaint. Its text was actually released only relatively recently. But it concerns issues on discrimination between Palestinians and Israelis in the occupied territories, in the West Bank and, according to the complaint, the West Bank, Gaza, and East Jerusalem, with regard to issues such as planning and building, family unification, criminal proceedings, access to natural resources, punitive house demolitions, labor rights, and a host of other issues. Just to clarify, under CERD, or under the various human rights treaties, states may submit complaints against other states. And as you can imagine, the first questions that came up was whether the committee even has jurisdiction over this complaint, considering that Israel's position was, and still is, that there is no state of Palestine, and therefore Israel does not recognize Palestine as a party to the convention. There are no treaty relations between the two, and therefore Palestine cannot submit a complaint against Israel. Now, this issue of jurisdiction was decided almost 2 years ago at the end of 2019, when the committee decided that it did have jurisdiction. Basically, there is a state of Palestine at least for the purposes of the convention. And I'm not going to go into that. I think this may have even been discussed in a previous session of the forum, but we always have the questions and answers session for this. Now, once the committee has jurisdiction to consider a complaint, there's a question of admissibility. And one of the grounds on which a complaint may not be admissible is if local remedies had not been exhausted. And this is what this decision is about. Basically, Israel arguing that irrespective of its objection to the jurisdiction question, local remedies have not been exhausted. Now, the idea of local remedies is that before one can approach the international committee, whether one is an individual in an individual complaint or a state, there has to be first an attempt to resolve the issue before the authorities of the state in question, the state against which there is a complaint, on the basis that the international committee can obviously not deal with all issues in the world. The natural place for resolution is domestically. If that is insufficient, then you can approach the international body. However, the rule on exhaustion, or the requirement of exhaustion of local remedies, has an exception. And the exception is when local remedies are in effect, do not exist. For example, there are states where you cannot appeal against the state. There is no equivalent of our High Court of Justice, or Bagatz, for example, or when domestic courts are known to be are ineffective, and therefore there is no sense in requiring the complainant to go through a process that we know in advance will lead nowhere. So the question, and then the rule is, when would we consider the exception to exist? When there is a recurrent practice of violations, or let me just clarify, when there's prima facie evidence, this is what is required at the admissibility stage, prima facie evidence of recurrent violations of the rights protected under the relevant convention, in this case, the prohibition on racial discrimination, and when those violations are tolerated by the higher authorities, the ones that are in a position to enforce the convention. So those higher authorities would be legislative or administrative or judicial. So the finding by the committee is that the requirement of showing prima facie evidence of, let me maybe look at the specific wording of it. That the threshold of prima facie evidence of a generalized policy and practice that touch upon substantive issues under the convention is fulfilled, and therefore the rule on, and consequently the rule on exhaustion of domestic remedies does not apply. And this decision was adopted by 10 members out of the 18 members of the committee. 4 members were absent, and 4 members objected to the jurisdiction of the committee, and therefore did not participate in the decision on the exhaustion of local remedies. So what I want to do in the following is say something about the specific findings of the committee. And let me just start by the fact that I think that the conclusion of the committee is actually correct, but I think it's completely by coincidence given its argumentation on the matter. And this is where I want to share the PowerPoint presentation. And basically okay, do you now see a PowerPoint presentation, and only a PowerPoint presentation and not the rest of the stuff that's on my screen? Good, okay. So because I want to look at specifically what the committee said, I thought that it would be helpful to have the text in front of us. So it's a 17-page decision, I think, and it's only the last 2 that actually have the decision of the committee. And I think the heading is the actual decision of the committee, like literally is what they called it, the actual decision. So what the court says, what the committee says is, and let me remind you, there's 2 conditions. One is that there's prima facie evidence of recurrent practice in violation of the convention and tolerance by the higher authorities. So the committee says that there's prima evidence that these conditions are fulfilled, and the prima facie evidence is available in the committee's own concluding observations on Israel. Now, let me remind you, every so many years, every state has to report on its implementation of the convention. This report is usually countered by shadow reports by various non-governmental sources. Then there's a constructive dialogue between the committee and the state to discuss the situation. And at the end, the committee publishes its concluding observations. And that's what they are, concluding observations. So in the concluding observations that CERD published in 2019, it expressed concern over a number of things, and some of them the committee is mentioning here. The maintenance of several laws that discriminate against Arab citizens of Israel and Palestinians in the OPT and create differences among them as regards a variety of issues, which are mentioned in the complaint. Segregation between Jewish and non-Jewish communities, lack of detailed information on racial discrimination complaints filed with the authorities. People belonging to minority groups may face the fact that people may not belonging to minority groups, including Palestinians, may face obstacles in accessing justice while seeking remedies for cases of discrimination, and reports that the judiciary might be handling cases of racial discrimination discriminatorily on the basis of race. And on this basis, and this is the basis for the committee's conclusion that in fact, there is prima facie evidence of recurrent violations and that is authorized by the higher authority, or it's some wording to that effect. So I want to say, I want to offer a few observations regarding these findings. Let me start with the fact that in order to establish, and the committee is very clear that it's not enough to allege violations, which is what the Palestinian complaint does. What is required is prima facie evidence, and this is the evidence that it offers. So the first thing that I would ask is, if the committee, which is a quasi-adjudicative body, needs to be offered evidence, how come it is relying on its own work as evidence rather than something provided for by the complainant or the plaintiff or whoever? Now, I don't know if Yuval would have something to say about it. I'm just wondering whether this is even permissible. Basically, this is the judge offering the prosecution its assistant, his or her assistants. And there's another question of why would the committee even want to do that? And I think the answer may lie in something that has to do with the jurisdiction. So I'm not going to go into it because it's completely speculative and we're not talking about jurisdiction here. But again, we've got the Q&A for this. But I want to talk a bit about what is the prima facie evidence of generalized practice. Let's start with the fact that the committee offers its concern over these issues. And what the concluding observation we have is concerns. Basically, we're concerned with gaps. We're concerned that there's possibly violations. It does not include facts, and evidence requires facts. And what we have is the report of Israel. We've got shadow reports. We've got a lot of proceedings of constructive dialogue. But at no point does the committee ever establish findings. I believe the state of Israel, or rather I give preference to data provided by one of the NGOs. There's no factual findings, let alone statements of there is discrimination in violation of the convention. So how can concerns be used as evidence? The second issue is that even findings of differentiation, factual differentiation. For example, segregation between Jewish and non-Jewish communities. There is segregation between Jewish and non-Jewish communities in various issues. Does that mean that there's discrimination? Now, I don't want to nitpick and go into the content too much, but there's a distinction there. So even as the factual segregation does not mean factual violation of the convention. So these are just, what I've got here is the 5 points that the committee made, and I put it in a slightly different order from the one that it's offered in the decision itself. The reason I ordered it like this is because I said there's two conditions, and the committee does not distinguish with them. It just gives these 5 points all in one paragraph, and then concludes, therefore, the rule of the requirement for exhaustion of remedies does not apply because we've got generalized practice that is authorized. So I assumed that the committee was trying to apply the standard rule. I was trying to be very, very conventional about this. And I think Yanni's here, and he has a different reading. He believes that the committee may have created a new rule of exception to the requirement of exhaustion of remedies. I'm assuming that the committee, trying to assume the committee did not want to do that. So I'm looking at what prima facie evidence does it have of violations and of tolerance. So for violations, it's got the first two bits. And in fact, the other three, but I think the other three go more to the question of, is there tolerance by the higher authorities of these violations? So we've got lack of detailed information on racial discrimination complaints. Basically, we don't know whether how the higher authorities are dealing with this, whether they process these complaints, how they do it, how they investigate, what their decisions are. But let me just tell you, lack of detailed information is not detailed information of tolerance by the higher authorities. It's just lack of detailed information. It's neither here nor there. Now, a state may be required to have that information available, but not having it does not mean that the courts, for example, tolerate discrimination. The second proof is that people belonging to minority groups may face obstacle in accessing justice while seeking remedies for cases of discrimination. Now, I don't think there's any dispute about this. People belonging to minorities groups, including Palestinians, do face obstacles. These obstacles may be, let's say, non-nationals not being able to access the court, which is actually not the case of Israel. Now, that would be a legal obstacle that might be discriminatory. Or there may be exorbitant fees to submitting a petition to the court when you want to seek remedy for cases of discrimination. For the less affluent, one could argue this is discriminatory against the less affluent. But there's other obstacles, for example, language barriers or different cultures. Not every obstacle is discriminatory. And if we regard every obstacle as tolerance by the higher authorities of discrimination, that means that every single state in the world is in violation of the convention because there's obstacles everywhere. And worse than that, apparently in every state in the world where there's obstacles, there's also tolerance by the higher authorities. And I think the problem here is the equation of obstacles with violations, and these two are not the same. And finally, the committee says there are reports that the judiciary might be handling cases in a discriminatory fashion. Namely, if a Palestinian, like to put it in plain words, if a Palestinian, if there's a remedy sought against an Israeli, then the court would be more lenient than if there's a case against a Palestinian for the same thing. And there are reports that the judiciary is doing that. But here, the committee, even in its concluding observations, was really careful. It didn't say that this is what the judiciary is doing. It just said that there are reports that do that. It was not willing to commit itself, even as a concern, to be its own concern. So how can it now substantiate tolerance by the courts? So the bottom line of what I'm trying to say in all of this is that the committee relied on non-facts to establish facts, and on concerns and a variety of issues to establish the point that there's tolerance by the higher authorities, where actually none of these things actually show, even if they're true in themselves, do not establish tolerance by higher authorities. I completely forgot to go through my slides that show the highlights of the issue, but let me just go to what I would suggest is an alternative analysis, because what I argue is that the conclusion of the committee is, I think, unfortunately correct. But how would I have gone about this? So let me start with, how do you establish practice? So the committee says in its decision, referring to the Palestinian complaint, it says that the allegations refer to measures undertaken as part of a policy ordered and coordinated at the highest level of government. So the Palestinian complaint provides the allegations and provides substantiation to them. It provides facts, numbers, case law, all kinds of things. The material is there, which is why, now, whether this amounts to prima facie evidence or not, one could argue about that. But that's what the committee should have done. And as I said earlier, instead of relying on 300 pages, the committee relies on its own concluding observations, which is odd. So this is to the element of practice, and to the element of tolerance. And I think this is the painful part. let me start with the Israeli response to the issue. Israel's response is that the High Court of Justice of Israel has heard thousands of cases involving Palestinian interests over the years. And it provides a number of cases as an example. Now, this is absolutely true. The Supreme Court has heard thousands, I think tens of thousands of cases over the years of Palestinians against the Israeli authorities. And then it continues, and has not hesitated to strike down executive policy and even legislation when these have been found to excessively contravene individual rights. Now, interestingly, there is no reference to this sentence. There's no supporting case law. And I think the reason is that this is simply not true. The Supreme Court has very much hesitated to strike down executive policy and even legislation. And this is where the point, I have to say, I don't know the expression in English, but for the Hebrew speakers amongst you, because, okay, only recently a book has been published about precisely this issue. And let me painfully summarize some of the book in what is said in the Palestinian complaint itself. The violations observed by Israel have either been considered by the Israeli Supreme Courts to be legal after they've been challenged, and this is precisely what is required. Tolerance by the higher authorities that are in a position to enforce. So when the higher authorities say this is lawful, then there's no point in appealing to these higher authorities. They're going to say again, it's lawful. Whether they're correct or not, doesn't even matter. The point is there's no point in asking for an answer that's already given. So they've either been considered to be lawful or constitute a general practice based on a general policy by the state of Israel rather than mere individual violations of cert. And this, and this is exactly the findings in the second edition of the Occupation of Justice that David Kretzmer and I have written, that the Supreme Court consistently either upholds Israeli policy as lawful or refuses to intervene in that policy and therefore does not strike it down as unlawful. It's true, there are a few cases where it struck down policy, I can count them on one hand, and even legislation, most recently in fact, but these are the extreme exceptions. It rarely does that, and when the Israeli response says, when those have been found to excessively contravene individual rights, I don't want to dwell too much on the word excessively, but let's say, does the court strike down policy when it contravenes individual rights? No, you can take the most, just to give it two examples, the construction of the barrier within the West Bank and punitive house demolitions. Punitive house demolitions have been upheld by the court as lawful. In a few cases, again, recently, the court in specific cases said, this house cannot be demolished, or in this house, do not demolish, but only block part of the building. But it does so on the basis of excessive harm, disproportionality to the harm to individual rights, but it upholds the policy itself. It does not say punitive house demolitions of Palestinians and the absence of punitive house demolitions for Israelis in the same situation is discriminatory. That it would not say. It did not. It refused to say that. It was a little indignant when the suggestion was even made. Again, the barrier, the issue of the barrier. The court does not say construction of the barrier in the West Bank is unlawful in itself, but in when the harm to individual is extremely disproportionate, it says, well, you'll have to move the route a little bit here or there. But again, this assumes that the construction of the barrier in the West Bank for the protection of the settlements, let me put it that way, is lawful. Now, I'm giving these two examples because our position is that neither one is lawful in itself. So these are just some examples, and I'm not talking about planning, which the court also upheld when it was argued that it was discriminatory, and the court said no, and I'm happy to talk about that in the Q&A. But basically, it's absolutely true that the Israeli court is not the place to expect a remedy for claims on discrimination in policy. Now, as we say in the book, whether the court is to be blamed for that, whether it can do otherwise, it's a good question, but it's besides the point. In terms of the committee, there is no point in accessing the court, in addressing the court when we know what the answer is going to be, and it's going to be negative. I think this is where the this ends. Let me just conclude.
We need to leave a few minutes for questions. Yeah.
Sorry?
Just let's try to leave a few minutes for questions.
Yeah, no. Okay, so let me just conclude by saying I think if the committee had adopted the same decision on the basis of the solid ground that I'm possibly offering, would that have made a difference? Would that make Israel cooperate with the committee more? Probably not. But I think it would have saved, or would save, the credibility of the committee, which goes beyond the question of how it deals with the questions between Israel and Palestine. And there's plenty more issues that come up, but I'm not even going to mention them, so other people have time. Thank you, and I apologize for running a bit beyond.
Thank you very much, Yael, and you have the privilege, since you have contributed, I think, the most out of all of the faculty members throughout the year to the activities of the forum. So we will hear all of the questions and comments in a row, given the fact that we don't have a lot of time. And we'll begin with Yuval, please.
Hi there, Yael. I'm from the car, but I'm making progress. Thank you for the presentation. Two quick comments. Well, a comment and a question. One is I think you're right on the on noting the some anxiety or apprehension about the use of concluding observations in interstate communication cases, interstate cases. It's true that it's a bit mixing apples and oranges, because the reviews, the state reviews, are not a quasi-judicial process. However, I would say that also in individual communications, this has been the experience of the Human Rights Committee. There is some flexibility about using reports, either by the committee itself or by UN rapporteurs, or sometimes by other actors, and the question is whether they have any probative value. And I think it is fair to say that if you have an allegation that is made and the state by one party, and the other party is not refuting that allegation in very specific terms, and you do have out there information which has some probative value, I think relying on that information is not a big sin, as long as you take it for what it is, and that is that it is information that has some probative value. And this is a jurisdictional, this is jurisdictional admissibility phase. This is not yet the stage in which findings on the merits are issued. So I would be, I would be somewhat less concerned than you may perhaps on this one. The second issue, I think, is more serious, and that is the question of what do you do with the claim of systemic discrimination and exhaustion of local remedies. Are you expected, as the state that is complained against, are you expected to provide a remedy to the systemic discrimination claim, or are you supposed to provide a remedy for each and every manifestation of discrimination, which in the end may create the picture of systemic discrimination? But for the individual in question, there would be very few courts in the world that would allow a legal remedy for a case of systemic discrimination. It's possible, but rather implausible. I think my understanding has been, with regard to exhaustion, that you need to actually go for the specific case that you are, the specific victims in specific cases must have their day in court with regard to their specific plight. I think this is also the understanding of the 1503 procedure, where you have an individual victim has to allege a sort of a systemic violation, but nonetheless, the question of exhaustion would be reviewed on a more individualized matter, to the extent that it is reviewed. So I would be interested to hear what your take is on this interplay, and whether maybe, because if we are talking about systemic discrimination in an interstate claim, the direction which the committee goes is a direction which eventually does away with exhaustion altogether. That's my intervention.
Thank you, Val. Yael, let's hear the rest of the comments first, please. Okay, thank you. And Elspeth, please, from NGO Monitor.
Hi, Yael. Hi, Sal. Hi, Yael. Thanks for your comments. I just wanted to, I guess I have a question for you on sort of what is the import of this decision? Because this is what's going to happen next in the procedure is they're going to appoint a committee to sort of do negotiations between the Palestinians and Israel. And since this has never happened before, and there's no procedure written down at all, it's unclear to me even what role this document is going to play going forward in the proceedings. Is this committee that's going to be appointed, does it even have to rely on it? Is it going to start afresh? Is it going to hold its own type of hearings? Is it just going to rely on the record that already exists? So that's sort of, one question I have. And then just sort of as a side comment, we actually were at the CERD session in 2019. And there is some interesting dynamics there because, for instance, there was Israeli Arab representative for the Israeli government, and they actually were not allowed to speak by the committee because they could not find a translator. So that's also just kind of an interesting point that person was not allowed to present to the committee. So just wanted to put that out there. Thanks.
Thank you, Anne. One last comment from Jan, and Yael, you can answer and conclude, please. Jan.
Okay, thank you for the presentation. It was really nice. Yeah, I also found it striking that the actual decision of the committee is so short. It's not really convincing in terms of reasoning. And also what you mentioned that the reasoning is not convincing as they do not make use of their own standards that they established, which they borrow from the ECHR, of course. But what I wanted to say with regard to what you said is they mentioned the laws of Israel. I would say that laws are always something that is officially tolerated, and it's like laws are general in application, so you also have a repetition of acts always. So I would say that repetition of acts and official tolerance rather refers to administrative practices and not laws. And I would also say that official tolerance does not mean what the court says, because that is the remedy. It's only what the state official says. So it's rather a requirement to say, okay, we don't have like a practice with regard to one group of people to another group, but it's like official, it's from the state. It's not non-state actors which are making this practice. Yeah, that's what I wanted to say. And of course, like this requirement.
Is it only me?
No, it's me as well. We lost Jan. Yeah, it's official. I think that we lost him. Maybe you should start responding, yeah.
Yeah. Okay. One is to answer Yuval's question. What do you do in cases of systemic discrimination? I think maybe
it's more coined on individual.
We lost you for a while there. Yeah.
Okay, is it better now?
Yeah, but
I just wanted to say that the whole requirement does not really make sense when it comes to systemic issues. It's coined on individual cases, and of course it has its origins in diplomatic protection. That makes sense, and it would also make sense if a state would protect its own citizen, like one individual or like a specific group of individuals. But it's, yeah, so
thank you, Jan.
Yeah. Okay. So what Jan's last words is basically my answer to Yuval, that in the case of systemic discrimination, I don't think the individual cannot vindicate those. This is actually what an interstate complaint could be appropriate for. The fact that the rule of exhaustion of local remedies doesn't sit well with that is because that rule was not adopted for states, it was adopted for individuals. So I think the answer you're right that this does away with the rule, but I think if the alternative is to do away with interstate complaints. Now, they're not such a hot thing. We didn't even have them until recently, which kind of, which is part of why it's a little difficult to answer this. Where we do have interstate complaints is in the European Court of Human Rights, which is, and the case law there is clear that you don't have to show that when you have an interstate complaint, you do not have, that the whole point is that it's abstract and you do not need to show every single individual complainant and what they would have required. And on the other hand, of course, you cannot require a state to submit itself to the courts of another one, which is why you have to have the interstate complaint. And when you say that every individual must have their court in day, I think we usually mean that in the sense that they're entitled to their court in day, to their day in court. Sorry, I'm not listening to myself. I don't think that they must exhaust their day in court if there's an alternative on the interstate complaint. But yes, it's a new thing. We're not sure how it's going to go. And I have to say, this is also my answer to Anne. Your guess is as good as mine, possibly better, because you actually know a little bit about how it actually works and not just the theory, but how how it actually works out. I'm guessing, generally speaking, it's going to be one of those things that are happening, and it's going to be without the cooperation of, without the participation of Israel. So if it's not it's lack of participation of one kind or lack of participation of the other. And finally, to what Jan said about laws always being officially tolerated, I would qualify this a bit by the fact that there is constitutional review of laws. And in fact, this is something that is discussed in the complaint, in the decision. One of the things that we're talking about is the basic law, Israel, the nation state of the Jewish people, which is actually not related to the occupied territories, but to Israel. And another issue is that the committee does not make a distinction between the two, but like I said, never mind all the issues that come up. So there is constitutional review, and this is still pending in Israel, which is why Israel's argument is, well, this is still pending. We haven't, which is a bit odd, because on the one hand, this is the law of the state of Israel. How can the government say, don't worry about the legislator, we've got the courts to get us out of this? And the fact that the higher authorities could not be the courts, but only the administrative authorities, I see your point. I think I'm not entirely sure I agree, because I think there's a distinction between having effective remedy as a substantive right and exhaustion of local remedies as a procedural requirement. But it's something that I need to give a little more thought to. So thank you very much for that. And thank you, everybody else.
Thank you very much, Yael. We will move now to the presentation by Eitan.
Okay, thanks, Tal. And apologies for everyone for disappearing on you and then reappearing, running around with my laptop to try and find the internet connection. It's been a bit of a challenge today, but hopefully you can hear me clearly now. So as I imagine Tal mentioned, I'm going to be speaking about the Commission of Inquiry that's been appointed. And the appointment of a Commission of Inquiry by the Human Rights Council to look into alleged violations following hostilities between Israel and armed groups in Gaza is, as you will all know, not a very new thing. We've seen this happening a few times before in recent years, but I think there is something new about the task that the Commission of Inquiry has been given in this case. And this has been given the task it has been given has been, I think, rather aptly being referred to as unusually broad latitude. That was how the New York Times described the scope of the latitude that's been given to this commission. And I want to say something about the content of the mandate that's been given to the commission. But I wanted to first put this in context. And by context, what I mean is a kind of discursive shift that's slowly beginning to unfold in the legal debate about Israel's policies and practices towards Palestinians. Slowly, and it's certainly not universally, but it's something that's beginning to happen. And I think this is another indication of that. And to illustrate, I want to share something about what happened behind the scenes in my own organization at the Diakonia IHL Center when we started thinking about the recent developments, the hostilities in Gaza and everything that preceded them and has followed since. So I think we were actually one of the first to publish on the situation. We published quite early on the 18th of May, but I've seen similar kinds of approaches by other organizations. So we called the legal brief that we published a legal brief on resurging violence and hostilities in Israel-Palestine. And we published this along with a timeline that kind of reached back all the way to the 19th century, recounting all kinds of milestones in the dispute about property in Sheikh Jarrah, and kind of recounting the connection that that had to events leading up to the hostilities last May. And this kind of framing, connecting the hostilities to events in East Jerusalem dating back quite far in time, elsewhere in the West Bank and in Israel, was important, we felt, because, I think together with just about everyone else reflecting on this, because there seemed to be a clear connection between what was happening, the build-up to the hostilities and these hostilities, and wider concerns about Israel's policies and practices. And these related to policies and practices involving dispossession, at least that's the way they're perceived by some critics, displacement, and discrimination both towards Palestinians in Palestine, but also in Israel's practices in its own territory. So that actually wasn't very controversial within the organization. What did give rise to a little bit of dispute, and this is just a reflection of the fact that everything is very politicized when it comes to our context, was the reference to Israel-Palestine, as opposed to Israel/Palestine. So quite a few people in the organization said, well, you know, we have to distinguish. These are two territories, and you can't treat them as though they're one entity. You have to distinguish between them, and there's a lot to be said for that. I mean, the whole logic of international humanitarian law, we're an IHL center, is kind of informed by those kinds of distinctions. The political discourse, the two-state solution, all this depends on treating these units as two distinct units. And I imagine we will return to the slash in future publications. But in this instance, we found it important to emphasize that there was one authority in control, and that its policies on both sides of the green line were connected. In particular, violations towards Palestinians, failure to apply the law towards Israelis and Palestinians in equal way. This all presented concerns about discrimination that we wanted to highlight, and referring to the fact that this is one authority seemed quite important. So that was a bit of a background about the internal dialogue, and it wouldn't be very interesting if this was unique to a medium-sized INGO, but it reflects a trend, I would say. And it's a trend that has examples like B'Tselem and Human Rights Watch adopting this kind of approach where they relate to concerns about Israel's practices across the territory under its control. They've used the label of apartheid to describe this, but part of the issue is the fact that they highlighted the fact that one has to treat the whole territory as one entity. And there are others that are following suit. And I think there's signs that this is happening also with some, to varying degrees, also in the statements of international organizations, UN organizations, people, special rapporteurs, et cetera. And I would also posit that this is a kind of natural consequence of a reality of prolonged Israeli control with little prospect of change in the foreseeable future. And so everyone's gradually kind of looking at this area that Israel controls and treating it as one thing. So all this is a long background to kind of speak about the unusually broad latitude that has been given to the Commission of Inquiry. And the resolution that decided to appoint this Commission of Inquiry, one can identify a few important respects in which the mandate that it has afforded to the Commission is really quite broad. So first of all, it speaks about an ongoing situation. So this term ongoing implies that the Commission can pursue an inquiry almost indefinitely. There's no kind of time frame for this, and it gives it a degree of permanence that's akin to investigative bodies documenting atrocities in Syria and other contexts, Myanmar. That's a development as opposed to previous commissions in this context. It also is not limited at looking at just the hostilities in Gaza, but instead, and hostilities in Gaza, and of course the attacks on Israel, but instead it's charged with examining, this is a quote, all underlying root causes of recurrent tensions, instability, and protraction of conflict, including systemic discrimination and repression based on national, ethnic, racial, or religious identity. And it's not confined just to the Palestinian, occupied Palestinian territory, but it is a mandate that applies to Israel as well. I mean, Israel could also mean Israel in the sense that that's where armed groups fired at, but everything, if one looks at the deliberations leading up to the decision on this mandate, it's quite clear that the intention to widen the gaze to Israel as well was there not just to look at the effects of armed groups' attacks in Israel, but also Israel's own practices in its own territory, which at least some of the people speaking in the discussions leading up to this decision to adopt the commission implied entail discrimination in the sense that law is not enforced in the same way against different groups in the territory under Israel's control. And this is informed by racial and a kind of broad sense of racial considerations. And I mean, this was made quite clear by a number of actors who spoke in the deliberations deciding on appointing this commission, and that included the UN High Commissioner for Human Rights, who first of all squarely linked the latest eruption in the conflict to the recent threat of evictions for Palestinians from their homes in Jerusalem, to Israeli police actions at Al-Aqsa Mosque or the Al-Aqsa Mosque compound, and also denounced what she called the excessive use of force in the West Bank. Human Rights Watch spoke there and made similar points. They mentioned the concerns about a common theme actually amongst all these speakers was to insist on root causes, the need to examine root causes. Of course, root causes, I mentioned we looked back to the 19th century for some things. You could look further back. There's a lot of debate about how to frame those root causes, but there seems to be this kind of agreement amongst many players that there's a need to look at root causes more broadly. They speak of root causes of oppression and persecution. In the case of Human Rights Watch, they added apartheid there. Another theme that's coming up a lot in the discourse related to this is a shift of emphasis. So some have articulated, some, for example, Michael Link, the special rapporteur on the situation of human rights in the OPT, but he's not alone in this, has spoken about a need to shift from realpolitik to an emphasis on rights. So the argument is that there's been an emphasis amongst actors reflecting on the situation, the Israeli-Palestinian conflict, on the sort of end political goal. And a lot of actors are saying now that's undermined the debate about securing rights and preventing rights violations. And there's a need to shift the gaze and to focus instead, while the political solution remains elusive, on effectively protecting rights. And that seems to be another kind of consideration that was informing the deliberations here. Almost across the board, there was an emphasis on the need to look beyond the events that unfolded in the clashes between in Israel and Palestinian armed groups. So not just to review the legality of the conduct of hostilities by both parties, but to have this wider gaze. And then I suppose there's a bit of a debate about how exactly to frame the boundaries of this wider analysis. I say almost across the board because Israel, for its part, when it reflected on this, did insist on the narrower kind of approach, focusing on the conduct of hostilities and emphasizing the fact that there are clear violations by the Hamas, which I think wasn't really disputed. I mean, many actors just chose to ignore the Hamas, but those that did refer to Hamas did acknowledge, including the UN High Commissioner for Human Rights, did acknowledge that it had committed violations of IHL in the way so it mounted indiscriminate attacks. But then what Israel maintained was that it was just acting in its self-defense and following the rules on the conduct of hostilities. And this has introduced in wider kind of legal debate on the hostilities, a kind of return to some of the debates that we've seen in previous rounds of hostilities where really, I mean, it's clear to everyone, I think, that that applying IHL, the rules on the conduct of hostilities, to an asymmetric kind of conflict in a densely populated area introduces many challenges. And there's room for a lot of debate around that. So it's kind of easy to understand why, from Israel's perspective, it's useful to kind of shift the discussion to that area where one can have this kind of sophisticated technical debates about appropriate policies and practices in hostilities in densely populated areas. We've seen some of those, but in general, and this seems to be the direction that the Commission is taking, there's a push to look beyond that at things that are happening beyond the hostilities, where I think it's a little bit more difficult to defend, or perhaps a lot more difficult to defend some of Israel's policies and practices. So perhaps I'll stop there. I realize I haven't spoken so much about the Commission, but it actually hasn't started working yet. And the only interesting point, I think, at the moment is the fact that this mandate and the scope of it. And other than that, some of the usual debates about who voted in which direction, etc. I think one could visit those, but I don't know how interesting or novel they are. The novelty, in my view, is the scope of the mandate. So I'll stop there.
Thank you very much, Eitan. As you see, we already have 3 questions, so I think you've said more than enough. Let's begin then with Shoshi, please. Shoshana Berry. You need to unmute, please, Shoshi.
Sorry, I have to speak in English. I want to ask my people that know me from the beginning of the forum, 2004, knows that from the beginning, when the question of the wall was raised, I pointed that we kind of having occupation of history while we don't insist on the mandate paper and the Utipus Seditis that is a principle in international law and wasn't applied in Palestine. And I think that this Professor Hirsch usually say that even if decisions of the international organization is wrong, usually they are corrected later, and it's not so dangerous. But I see that from 2004 till now, it's the same time of the existence of the forum, there is a complete deterioration, and now we don't speak about the state of Israel, we speak about the state of Palestine. And I think that this is because of the weakness of the juridical טיעונים versus the army and the security activities. And from this point of view, it's a complete failure of the juridical system of Israel and academia. If you can comment on this, because you are in an NGO, and I don't know if you're aware to all this history, not from the 19th century, but from the 20th century about Palestine.
Thank you, Shoshi. We will hear all questions before the response. Yuval, please.
Thank you, Eitan. I wanted first to agree with you that the war in Gaza is really not at the focus of this, almost an afterthought. It's really about the interesting development here is essentially the espousal of the systemic discrimination / apartheid narrative, and this is, I think, the direction that this is going. I have 2 questions, however, for you, Eitan. First, the issue of I think you made a very incisive comment about Michael Link and the shift which you described from realpolitik to talking about rights. But I wonder what your thoughts are about this shift. I can see that if you're, I mean, there would be some political actors that would be interested in going in that direction, but in terms of pushing for some resolution, for addressing some of the specific issues, I have serious doubts whether this is going to, you know, to in the end to be constructive. Maybe that's, you know, inevitable to the terms of the debate, because once you throw out realpolitik from the room, then you're left with, you know, irreconcilable narratives. And you've heard, Shoshi, now, Israelis also have their own narratives, and some of them. And so I'm wondering, as an NGO working, as someone working in an NGO working on the ground, what is your impression? And secondly, of course, look, the issue with, you also prefaced your comments that this is not new. And I'm wondering whether at some point, I mean, at what point in time is the, you know, the fact that you have a special agenda item and you have an open-ended mandate of a special rapporteur, and now you have a third mechanism put on top of this, which is the open-ended commission of inquiry. At what point would these self-reinforcing but ultimately repetitive mechanisms would be deemed or could be deemed counterproductive for those who actually want to generate a meaningful impact on the situation on the ground?
Thank you, Yuval. Em, please.
Hi, Eitan, thank you. I kind of want to just carry on from what Yuval was saying. I just don't think you can talk about the Human Rights Council without looking at the political dynamics in place, because the way the votes break down, you can get any resolution passing whatever you want about Israel, even if you have every other, you know, democratic country on your side. And this vote, even though you didn't want to talk about it, was actually quite interesting because it was the closest vote there's ever been on these special mechanisms for Israel. It was 24 to 23 when you add up the abstentions and the no's. There were the most no's out of any resolution on Israel looking at a special mechanism. And even when I actually spoke at the debate, but when you also listen to the country explanations of votes, the yes votes, many of them did not agree with making this a permanent thing. The UN mentioned it was going to cost $8 million a year to keep this going, which is unprecedented for any fact-finding mission or commission of inquiry. So I think that's also of note. In terms of it reflecting something new, I also have to disagree with that because that it's permanent, because in addition to what you've all mentioned within the Human Rights Council, and I'll just mention that the Special Rapporteur mandate never expires. It's the only mandate that doesn't have to be renewed every year. But also within the framework of the General Assembly, you have the special committee that's been meeting since 1968. And you have the Committee on the Inalienable Rights of the Palestinian People that reports every year. So there are many permanent mechanisms looking at this situation. To me, the most interesting aspect was, is this going to be a commission of inquiry akin to what they have for Myanmar, where it's kind of, because it hinted at that in the resolution, that they're going to be collecting evidence for criminal proceedings. But they didn't really call it that. They didn't call it an independent mechanism, independent fact-finding mechanism. So to me, that was the more interesting piece. How is this commission going to be set up? Is it going to be that type of commission? Or is it going to be just like what we've seen in the past, the Goldstone, which also still reports at every council session on its progress. So again, there's another permanent mechanism to add that in. So, you know, those were the comments I wanted to put out there.
Thank you, Anne. Eitan, are you up for one last question?
Yeah, well, I don't know if I have an answer to any of the ones up till now,
So
but
you can choose. The more you have, the more choice you have between them.
let's go for one more then.
Perfect. Tamar, please.
Thanks. I just wanted to ask what you think the incentives will be about, like, because of the decision to make this an open-ended commission and not a commission with a certain deadline or like very defined borders. So what would be the incentives on both sides?
Thank you.
Okay,
Please,
so I'll try and say something in order. So, I mean, first of all, the debate about Palestine and the state of Israel, and so, I mean, I've been exposed to that. I sort of grew up on the narrative of the state of Israel in my kind of, never mind, my background. And now I'm exposed to a different narrative where people speak about the state of Palestine, and they don't mean in the 67 borders. There are people who, so I mean, yeah, Yuval also indicated there are many different narratives. In the international community, it's kind of concentrated around this debate about, traditionally about what I described as Israel/Palestine. So we've kind of had this vision of a two-state solution where the states would exist alongside each other. And I think that was a development that I was trying to hint at, not necessarily because they don't think that that's a better solution, but for different motivations and different reasons, a lot of actors are reflecting on this whole territory as one unit for very different reasons, actually. I was just pointing to a development from the perspective of some of the human rights NGOs, humanitarian actors, and perhaps it's widening a little bit. And that was to, at least for some issues, to reflect on this territory as an area under the effective control, either because it's a sovereign or because it has control over the territory of one entity, Israel, and to sort of analyze the ramifications of that. And it has a lot to do, and it involves looking at Israel's relationship towards Palestinians in the occupied Palestinian, what we call the occupied Palestinian territory, and in Israel's own sovereign territory, and to kind of reflect on perhaps certain patterns that are recurring there. So that's a development, whether, you know, and you can have different attitudes about that. It's obviously there are different narratives. I agree with that. And yeah, I'm not speaking on behalf of any one of these narratives. So depending on what you prefer, you can speak about how effective strategies have been. For Yuval's second question, at what point will these various mechanisms be counterproductive? I mean, I don't feel I'm speaking here on behalf of any of these mechanisms. I also, I mean, just to jump to what Anne was pointing out, yeah, I think it's obvious that there's, in these intergovernmental organizations, there's a lot of politics, and one can see that play out when you just look at who voted in which direction. So yeah, I mean, I accept that. Of course, yeah, I'm a bit skeptical about how much these regimes can deliver, but I mean, perhaps we'll have to wait and see. This is, despite what Anne said, I think a slightly different sort of a regime, although I accept your point about there being other entities that are looking at the context in a permanent way. But we'll have to see. I am a bit skeptical. The point that I suppose I should, I mean, so I'm tempted to invite Yuval to kind of join in on the strategic reflections on the question of what should be the policy when thinking about realpolitik, or this shift towards rights. From the narrow perspective of an NGO, it's a little easier to kind of place the emphasis on rights, because that's in a way it's more inherent to our mandate. But I mean, overall, these rights are being implemented within a political context, and I think disengaging from politics is not something that's really sustainable. And so I'm not sure. Yeah, so maybe this articulation of kind of disengaging from realpolitik is the wrong thing. What I do think is correct, though, is to put up a little bit of resistance to a narrative that's a counter argument that says, don't push these right claims now because they get in the way of the pursuit of a political solution that's on the horizon. I think most people don't feel there's a political solution on the horizon. There's no, and because of that, there's less patience to kind of defer rights claims so that we can conveniently can smoothly get to a political solution. There doesn't seem to be a political solution anywhere near. So I agreed with Anne, surprisingly, on some of her comments. Yeah, I mean, I think what is interesting to me, though, is not the way states voted here and what states said, because that is a reflection of their you can, as I think Anne said, you can kind of guess who's going to say what in advance. In this case, I think there was some more resistance from some of the states that have a strong commitment to political solution to some of the rhetoric that was being expressed. But what I think is interesting is to listen to what some of the the other actors were saying. So, I mean, Human Rights Watch, we've heard and these other civil society organizations, there's a difference in tone, but also from the UN organizations that were speaking there. I think that kind of shift is something to take note of, whatever your position is about that. There seems to, well, I described it as a kind of discursive shift that hasn't been accepted by everyone, but it's gradually, even, I mean, this language of apartheid, whatever you think about that, it was something very marginal, I think, for a long time. It was expressed mainly by, well, marginal outside of Palestinian civil society, I'd say, because there it's been quite dominant for a while. But it's gradually, I'm noticing it, people are taking this kind of language up. And I think it's going to be something that everyone's going to have to contend with, whatever their position is on that matter. So I think there is a shift that's taking place that might be interesting to reflect on. Tamar's question about why the kind of, well, in general, the extension of the mandate. I think, I mean, the rhetoric surrounding that was this approach that a lot of speakers that in the build-up to adopting this, the decision to appoint this commission, what they emphasized was the need to look at root causes and the need to be engaged about these ongoing concerns. So their analysis was that these hostilities are going to return again and again, and we're going to have another commission of inquiry on the next round of hostilities, and this is going to recur if there isn't an effort to address root causes of this. And that requires a kind of analysis that goes beyond the violations that may have been committed or certainly were committed in the context of the hostilities to broader concerns. How those root causes are framed is, of course, something that one could dispute, and they're going to be different, again, connected to these narratives that different actors have. It's going to be different framing of the root causes, and how this commission decides to frame the root causes is probably something that there's going to be a lot of disagreement about, but I think that was the logic. That's at least how it was articulated. I hope that's a bit helpful. Thanks, everyone.
Thank you, Eitan. You promised to answer some, but you answered all questions eventually, I think. So
I'm not sure the answers were satisfactory.
You lowered expectations, so brilliant. Thank you very much, Eitan. It was excellent. We will now take a step back away a bit from Israel, but a topic which is not totally unrelated to these parts of the world. Amir, the floor is yours, please.
Hi, first, thank you, Tal, for inviting me to discuss this recent judgment by the Grand Chamber of the European Court of Human Rights, the matter of the Big Brother Watch versus the UK. This judgment was released about a month ago, and since we are likely to run out of time, I'll start with a spoiler, and then I'll elaborate on the background of the case and its main points from more of a bird's eye view. In a nutshell, the Grand Chamber reaffirmed the legitimacy of state-mandated online surveillance practices for national security purposes, and rejected the argument that they are per se illegitimate. And it did made some adaptations to its long-established case law regarding the particular characteristic of untargeted mass surveillance regimes. Another thing that should be noted is that alongside the Big Brother judgment, which related to the UK bulk interception regime, it had, let's say, a little brother, which is a judgment that came alongside with it in the matter of the Centrum for Visa versus Sweden. I'm doing a German accent, but I'm not sure if this is the proper one. It deals with the same subject matter, that is on mass surveillance legal frameworks, this time the Swedish one. And it basically applies the same logic on different set of circumstances. Due to time constraints, I will discuss here only the Big Brother Watch judgment. So this case originated, as most of the mass surveillance jurisprudence of this decade, with the Snowden revelations back in 2013. and it is alongside with the Ratvisa judgment. It's latest in the let's say legal and policy jurisprudential shockwaves that the Snowden revelations brought forth. So the discoveries made by disclosures made by Snowden, either revelations or maybe reaffirmations of ongoing rumors and feelings regarding gut feelings regarding the mass surveillance practices of the U.S., its intelligence sharing arrangements with Five Eyes and other partners, international partners. All of them prompted debates both on the international and on the national levels as to the desired extent of signals intelligence interception. It's the proper interference it should have with fundamental rights, especially the right to privacy, and the suitable safeguards that should be applied to avoid any violation or infringement upon these rights. Alongside the American programs that were revealed in the Snowden disclosed, revealed their existence, known as the Upstream Collection Program and PRISM program, Snowden also revealed the existence of Tempora. It's a UK-based bulk collection operation. It's basically they siphoned and stored mass volumes of internet communications from international submarine fiber optic cables, most of them transatlantic. It means that all of the data flowing from the EU to the States was accessible to British intelligence. And following these disclosures, there were several parliamentary reports in the UK that admitted that indeed the UK did, through its signals intelligence agency, GCHQ, was running two major bulk operations. And this naturally prompted a complaint by a score of human rights organizations to the first an internal complaint to the Investigatory Powers Tribunal, which is a UK specialized tribunal designed to address complaints regarding investigatory powers of the police and the intelligence services, especially complaints about misuse of these powers, and including powers pertaining to online surveillance measures for wiretapping and or data acquisition. And the basic claim already in the level of the IPT, the Investigatory Powers Tribunal, was that UK intelligence services has been violating Article 8, 10, and 14 of the ECHR, the Human Rights European Human Rights Convention, both by using intelligence sourced from the US programs and by using and applying their own operations, Tempora operations. However, and it's not quite surprising, the UK tribunal was more or less satisfied with the legal arrangements covering both these issues. Once the only fault that it was found that it found and was immediately remedied was that these arrangements, the safeguards surrounding the operations of these programs were not sufficiently disclosed. Since during the proceedings, these arrangements were publicly disclosed to the satisfaction of the tribunal, there was no other violation to be found. So it is not surprising that following this decision, an appeal has been brought before the European Court of Human Rights, arguing for a violation of Article 8 of the Convention, the right to privacy. And the chamber, the lower chamber, determined that the decision to operate a bulk interception regime, firstly, it falls within the margin of appreciation afforded to a contracting state, namely, it is not prohibited per se. However, it does require a set of safeguards and compliance with already established case law criteria established in case law as to the to assess the quality of the law governing these measures. These criteria are known as the Weber criteria from previous case approximately 15 years ago regarding an interception regime that should cover specifically disclose the nature of the offenses that may give rise to an interception order, definition of the categories of people liable to be to have their communications intercepted, should set a limit on the duration of interception, and the procedure to be followed to examine the material intercepted, and so on. There were like six criteria under these Weber criteria, and they were applied by the chamber in the Big Brother decision with slight adjustment for bulk interception. And some attention was even given to oversight arrangements. When applying when applying the law to the UK regime, and it was not the UK regime, and it was the old UK regime pre 2015. Since 2016, there was a significant reform in British surveillance law, which instilled much more safeguards and oversight functions in the system. The chamber identified two areas of concern in the old UK bulk interception regime, which was the subject of these proceedings. First was the lack of oversight in the selection process of internet bearers, subsections of the cables that relay information between the UK and the States, for our matter, and a lack of safeguards for searching and selecting for examination data from the bulk that was collected. So it was held by the majority at the lower chamber that the bulk interception regime did not meet the quality of law requirement and was incapable of keeping the interference with Article 8 to what was necessary in a democratic society. As I said, it did not have an actual impact on UK mass surveillance practices, as the Regulation of Investigatory Powers Act, the old act governing these surveillance measures, was already, the one that was examined by the chamber was already replaced by the Investigatory Powers Act 2016. That particular piece of legislation was subsequently, after the judgment of the lower chamber in the European Court of Human Rights, in the matter of Big Brother Watch, that piece of legislation was challenged domestically in the UK National Court, and the UK High Court found it to be incompliant with EU law. So no surprises to hear. Which brings us to the current judgment. So the applicants of the Big Brother Watch of the lower chamber, they appeal to the grand chamber of the European Court of Human Rights, and they focus the arguments on two areas. Firstly, contended that bulk interception is, in principle, neither necessary nor proportionate within the meaning of Article 8 of the Convention. Meaning, as such, it does not fall with the state's margin of appreciations. Secondly, they also argued that there was a sea change, both in aspects pertaining to societal use of technology and in technology itself, that requires the court to update its existing approach and enhance necessary safeguards. The Weber criteria that were set more than a decade and a half ago, before there were social networks and smartphones and the growing human use and dependency on these devices and web services that log any minute detail of human activity, required a revision of the way you assess the safeguards surrounding or installed in a bulk interception regime. They suggested that maybe ex-ante judicial oversight of warrants, tweaking any grounds for interception to have a reasonable suspicion standard, and they also applied for a subsequent notification of any clearly defined surveillance target. So the right to be notified that you were surveilled after the fact. As to the Grand Chamber's decision, well, it would be a bit far-fetched to expect it to declare mass surveillance measures as categorically disproportionate. And indeed, the Grand Chamber upheld the Chamber's finding that the bulk interception of communications by intelligence services is not per se incompatible with the Convention. It stated that these programs are valuable and they have vital importance to security of contracting states. Nevertheless, the Grand Chamber did acknowledge the differences between targeted and untargeted interception regimes, and accordingly, he acknowledged that there's a need to adapt the existing case law, the safeguards in the existing state law to apply for bulk interception regimes. It developed new criteria. Most of them can be matched into the existing one. Due to the lack of time, I will not list them. I'll just mention that the most prominent addition is the requirement for oversight by independent authorities, both ex post facto review and in real time. When it applied these criteria to the old UK regime, the Grand Chamber engaged in a holistic approach. It did not assess each of the criteria independently, and when we found one not to be in compliance, when he found that the UK regime is not in compliance with one of them, he did not necessarily strike down the entire regime, but was willing to accept maybe stronger safeguards elsewhere, a more calibrated version, and again, a holistic point of view. And was looking at the law as a whole rather than a set of independent criteria. So, for example, the Grand Chamber found that the grounds for bulk interception under UK law are relatively broad to start the grounds to intercept, but it did not strike the entire regime. But it proceeded to examine its remaining safeguards to determine if, as a whole, they complied with Article 8 of the Convention. And the court did eventually find out that the authorization procedures under the UK regime were lacking, and that the oversight functions under the old law were not sufficient to overcome these deficiencies. And accordingly, the Grand Chamber found a violation of Article 8 of the Convention. So the Big Brother judgment, when compared to the recent case law from its say, sibling, the European Court of Justice, which was very prolific in the last couple of years with it's called the Codonat of the Net judgment, Privacy International judgment, the Schrems II judgment. European Court of Human Rights offered a more holistic approach. It did not prohibit mass surveillance per se. It did not. It wasn't as hard line in its approach as European Court of Justice, but it offered a more softly principled proportionality assessment. It should be noted that some dissenting opinions were critical of the language of the judgment, of the majority opinion, pointing out that there were opaque terms that the majority opinion adopted from basically the discourse of governmental agencies. The opinion used the term below the waterline arrangements for secret laws or secret rules, and relied heavily on the imperative language. It should be done like this, should be done like that, and the judge Pito del Bartocchi suggested that in some corners of Europe, zealot secret services will be strongly tempted to take advantage of the court's very lax fashion of formulating legal standards, and innocent peoples will pay the price sooner or later. On the other hand, this holistic approach do stress out the need for strong end-to-end independent oversight functions, mostly ex facto, but the application of these standards on the UK law bulk interception regimes may suggest that also prior independent authorization might be in fact a must. And the existing legal framework in the UK now contains an independent oversight body, which on several occasions actually uncovered some mishandling of intercepted data. So it's not the much hailed landmark victory for privacy as some of the NGOs, which were the applicants, declared, but it more acts as a reaffirmation of a status quo under which mass surveillance measures are legitimate for national security purposes, and maybe retouching a bit proportionality standards by rendering what once was optional independent oversight to a mandatory criteria. Thank you.
Thank you very much, Amir. We have a question by Yuval, please.
Well, I mean, it's more maybe of a comment, but maybe I mean would react briefly. So I think it's I mean, as Tal introduced, this is not totally unrelated to Israel. Both, I think it's an interesting case. We just had a discussion about the choice between realpolitik and rights, and I think the court maybe has been criticized, but it's clearly been taking the route of realpolitik in these cases by not actually putting a standard which it knows that states would not be able to realistically to meet. How far do you consider Israel to be from this end-to-end oversight standard that this realpolitik standard that the court introduced?
This is a complex. It's a long answer, so I'll make it short. We're not there. Certain areas of mass of Israeli civil activities are not covered by law to begin with. So we don't know what are the oversight arrangements from the offset. And as we have experienced during last year, it appears that the oversight that is, let's say, that has become the veil that the corona pierced, the veil of secrecy that corona pierced as to the working of the salient oversight ecosystem when it comes to internal domestic collection of metadata. What we have seen is that the performance of this entire oversight apparatus is unsatisfactory. So I will not assume that they are even close to compliance with these standards.
Thank you very much, Amir. I think that it is time to say goodbye to some and see you soon to most. We have reached the end of the academic year. Thank you very much to Amir, Eitan, and Yael for joining us for the last session. It has been a special year. Let's term it that way. We opened it with a question mark, but we are finishing it with a strong hope that we are getting back to reality and that in the next academic year, the International Law Forum will operate hopefully on a hybrid fashion, so we will be able to enjoy all worlds. Thank you very much to Professor Yuval Shani and Professor Moshe Hirsch, the directors of the International Law Forum, for letting me be part of the family for another year. And thank you very much to all of our guests and to all of the participants which are joining in all of the session. And of course, congratulations to all of the students which are graduating from the International Law Workshop. I hope to see you again in the coming sessions as our guests. And stay in touch. Take care. And goodbye to everyone.
Thank you. Thank you.